Hi, everyone. Welcome to another roundtable, immigration litigation roundtable with the Amica Center Immigration Impact Lab. We're so grateful to have you here. I'm here with my colleague, managing attorney Austin Rose. Thanks for leading us on this topic today, Austin.
Absolutely.
And
Happy to be here.
amazing. Still having folks rolling in. So just want to say, hope everyone's
It's
hanging
just
in
some
there
spray
okay.
roses.
Please do mute. Thank you. Hope everyone's hanging in there okay. No, these are very hard times for all of us. So we appreciate you making the time to come learn about detention and ways you can challenge it, as that is clearly increasing right now. Austin won't say it, he's very humble, but I will just brag that he really is an expert on habeas. So glad that we're able to learn from him today and his experience challenging immigration detention the past several years at Amica Center. So yeah, we'll be covering defending immigrants in the mass deportation machine, fighting back against the rapid expansion in mandatory detention. And for those of you who are new to the Amica Center for Immigrant Rights, welcome. We are formerly CARE Coalition, changed our name last summer to reflect our broadening work outside of just the capital area. We work throughout really the Mid-Atlantic, a bit in the Southeast as well. Our focus is on immigrants who are detained and facing deportation. Most of our work is direct representation, removal defense for people detained. But in our immigration impact lab, where Austin and I work, we focus on impact litigation and a lot of habeas work and appeals. Our focus is on defending one another. We engage in unwavering legal defense and strategic litigation for immigrant children and adults facing detention, deportation. We believe everyone deserves access to due process and legal representation, and we work every day to make that a reality. The lab, as I mentioned, that's where we house our impact litigation work. We do a lot of work that starts at the individual level, at the IJ, or in the district courts when it's a habeas petition. If it is removal proceedings, we'll go up to the board and the Court of Appeals, and many of our cases end up making regional or national impact. So I'll turn it over to Austin to get us started.
Thanks, Adina. And I see some friendly faces rolling in. I'm glad to be with all you in this really, really scary time. It is not anything we want, but there are opportunities to fight back. And so, I'm excited to talk with you all about that today. So I gave a training on habeas more broadly in October that some of you all may have been may have attended. It's okay if you didn't. This training is going to have a narrower focus and a more updated focus given the Trump administration. So we're going to be focusing on the fact that the Trump administration, through various means, is expanding mechanisms for mandatory detention. We'll talk about what mandatory detention is. Essentially, it's detention without the opportunity for release, at least through an immigration judge. We're going to particularly focus on the Lake and Riley Act, which is this new terrible legislation that unfortunately many Democrats even supported, that broadens mandatory detention grounds and will make many more people subject to mandatory detention, along with other avenues that the Trump administration is taking. So we'll define mandatory detention, talk about the various forms of it, briefly discuss about how to challenge mandatory detention and the new ways we might challenge it. And then, as always, in these sessions, we'll do some group discussion and would love to hear from you all because there's a lot of experienced advocates on this call, and you all are on the ground level just like us, and we want to hear from you. So if there's questions as we go, you can put in the chat. I think that's the best way to do it. And then if it really requires that you want to say it orally, I think we could do that. Adina will flag like important questions to me, and she might ask her own questions to facilitate discussion. All right, so what is mandatory detention? You can keep going, Adina. Thanks. And first, before we get into what is mandatory detention, why is it important? Because, deportation and detention are two different things, but as we all know, they clearly intersect. it is very difficult for ICE to deport people unless they subject them to mandatory detention. And in fact, no one can be deported unless, except for, or no one can be deported without at least a brief period of detention in almost every situation. And so, mandatory detention facilitates ICE's in attempts to do mass deportation. It will fill up the detention centers with a lot of people that shouldn't even, that if they had a bond hearing would likely be released. And that's what's so unfortunate about it. Obviously, we believe no one should be in ICE detention, but we're going to see more people for which ICE hasn't even determined and would not determine themselves that that individual is a danger or flight risk, but they're still going to end up detained with very little recourse, except for what we're going to discuss today. So we'll talk about the authorities for mandatory detention. Mandatory detention, in effect, as I define it, is detention without access to a bond hearing before an immigration judge. And there are many different forms of mandatory detention, at least again, as I defined it. I think the term is thrown out a lot and it can mean different things to different people, but I'm defining it here as you are detained and you do not even have the right to ask for bond from an immigration judge. So the most recognizable, I think, form of mandatory detention is under 8 U.S.C. 1226C, 236C in the INA. This is mandatory detention for a criminal conviction. And this is the probably the strongest form of mandatory detention in the sense that you have no eligibility for bond for an immigration judge, and ICE would say at least that they cannot release you even in their own discretion, that they don't even have the power to do that. Now, they do in reality have power to release anyone in their discretion, and we have seen that. But like if you are subject to mandatory detention under 1226C, you have essentially no recourse except for a habeas petition because both avenues are blocked off. Then there's two other forms of detention that might not sometimes be called mandatory, but I view as mandatory because they similarly do not allow for bond. One is 1225B or 235B in the INA. This is for applicants of admission, sometimes referred to a subset as arriving non-citizens. So these are folks who are not eligible for bond by virtue simply of the fact that they sought entry at a port of entry and typically went through expedited removal. We'll talk about that. ICE can release these individuals. The sole mechanism for releasing them is through parole. And that happened a ton during the last administration and has happened throughout ICE's existence. But as we all know, that's going to happen very infrequently under this administration. So this, in effect, is also detention without any opportunity for release because ICE is the sole arbiter for it, and they're not going to release these folks. And then finally, there's post-removal order detention, which is mandatory in some circumstances. There's no bond eligibility. You're not eligible for a bond hearing if you have a final removal order, various manifestations of a final removal order. ICE does have the discretion statutorily and under regulation to release those folks in most circumstances, although they would quibble with that a little bit. But again, no eligibility for bond.
Thanks, Austin. And I know we're going to get to later in the presentation the tool of habeas to challenge detention in these situations. But while we do have the statutes up here, can you just clarify, is habeas viable in all three scenarios? And, at Amica Center, have we done that for all three?
Absolutely. Habeas is viable for all three scenarios, and we have done habeas petitions for all three situations. All right, so I'm going to go a little bit more in depth into each ground of mandatory detention before we talk about the grounds or the ways to challenge it. So the convictions that subject people to mandatory detention are very broad. I'm sure many of you know this, so I won't get into the weeds, but we've got aggravated felonies, which, as we know, could be something that's not aggravated or a felony, but it's still defined as an aggravated felony. There's crimes involving moral turpitude. So even if you don't have an aggravated felony, you might be subject to mandatory detention if ICE can show the elements of a crime involving moral turpitude. There's other grounds that don't need to be either of the above two: drug offenses. So with the exception of petty possession of a small amount of marijuana, virtually every drug offense is going to make you subject to mandatory detention, and firearm offenses, including mere possession of a firearm. So there's a really broad swath, and again, it means that a lot of people have no eligibility for bond hearing, even if they'd likely win one. Now, the Lake and Riley Act is an expansion of the mandatory detention grounds, and it's very bizarre and in nature, in the sense that all the other, or most of the other mandatory detention grounds are based on removability grounds. So it's the reason that ICE starts removal proceedings in the first place, and then they also trigger mandatory detention. But the Lake and Riley Act, they're not new removability grounds. They're not a basis to remove someone in the United States. It's just anyone inadmissible who also has these offenses. And it's charges and arrests, doesn't have to be a conviction. So this means that we have this broad swath of charges and offenses that will make people ineligible for bond. Um, and it will often be raised by ICE at the last minute without notice, and we'll talk a little bit more about that. But the arbitrary offenses that are under this, and they seem to just come up with this based off of capitalizing on tragic events that occurred in the United States previously. So it's burglary, theft, larceny, and shoplifting. Essentially, any theft-related offense, an arrest or charge for that will subject individuals to mandatory detention. Assault on law enforcement, and any crime, quote, resulting in death or serious bodily injury. So this is, again, going to mean a lot more people are subject to mandatory detention under 1226C. 1225B. Essentially, this is a complicated category, and it's rather arbitrary how ICE decides whether to charge this or categorize people as this. But essentially, it is anyone who went through expedited removal, no matter if they got through it and are now in full proceedings. So as many of you know, people might go through expedited removal at the border. Increasingly, they might go through expedited removal anywhere in the country due to the Trump administration's expansion of it. And if they pass what's called a credible fear interview, then they enter full proceedings before an immigration judge. But even if they do that, they remain detained under BIA precedent to under 1225B. So they're in the same situation as anyone else, but they happen to be ineligible for bond by virtue of having gone through expedited removal. So you can normally tell that someone is this when they are charged with the inadmissibility ground in the NTA 212A7. And Chris, I will get to your question on the Lake and Riley Act, and I think there was another one. I'll get to that as well. So this is applicant for admission, and you can normally tell that this is raised because of that charge in the NTA. In addition, there's a kind of a subcategory called, quote, arriving aliens. I use the term that they use, which of course we don't endorse the use of the term alien, arriving non-citizens. This could even include people who are LPRs and returning to the country seeking admission. This you'll normally know because they'll check a box on the NTA that says you are an arriving alien. So these are the ways you know that someone is likely, ICE is likely going to purport the person to be ineligible for bond. As I mentioned, the government can release these people. It's not that they can't release them at all, but they need to release them through their parole authority. And several memos have been released by the Trump administration, executive orders, effectively saying that this should be used very sparingly. My guess is that they only use it if they need to do it for bed space purposes, but that they will not do it in response to a release request. I could be wrong, but I think it's going to be, of course, much less frequent that people are released through parole requests to the point where they might become largely futile. And then finally, post-order detention under 8 UC 1231, that's 241 in the INA. That's anyone who has a final removal order. And this can get tricky because sometimes you might not recognize someone as having a final removal order because their posture doesn't really match up with that, but they still do. So the most recognizable scenario is, you go through immigration court, the judge orders you removed, maybe you appeal to the BIA dismisses the appeal. That's the classic final removal order. But it's also reinstatement, right? So if you are deported and then you come back, you might enter what's called withholding only proceedings and be seeking relief just like anyone else. But the fact that you have a previous final removal order means you're subject to this provision and you're ineligible for bond. There's also a thing called a final administrative removal order, FARO. This is issued to people with aggravated felony convictions and essentially cuts off some forms of relief and it's essentially a form of expedited removal. It's not used that all that commonly, but I expect it to be used more. And again, even though that individual might enter withholding only proceedings, they still have a final removal order. And then obviously, if you are detained and you are trying to reopen your case, but you haven't yet done that, you are still detained post order. So all of these people aren't eligible for a bond hearing. In general, the first 90 days of detention with a final removal order is mandatory, or ICE would say it is. But after 90 days, it is discretionary. So if ICE is ever telling you that they cannot release people in this posture, that is fundamentally incorrect. Although they retain, again, the discretion to do these custody reviews, what's called post-order custody reviews. And as many of you probably know, they're perfunctory and lacking in due process. And so again, ICE is the sole arbiter for these types of detention.
Do you want to mention a little bit about the class actions while we're here?
Sure, let's do that later, actually, when we talk
Okay.
about the challenges. So in summary, and I want to get to the challenges because this is all the really bad stuff, and we want to talk about how we can
Yeah.
challenge it. But effectively, there's all these existing mechanisms for mandatory detention, and through various ways, whether that's executive action or legislation in the case of Lake and Riley Act, there are going to be more people falling under these provisions, basically. And there's going to be, I expect a situation in which the majority, if not the vast majority of people in ICE custody are not eligible for a bond hearing. I should note that the only provision that under which someone is eligible for a bond hearing is 8 U.S.C. 1226A or 236A. So that's essentially anyone in removal proceedings who doesn't have any of the situations I described. But I don't think there's going to be many of those people. We're going to have more people under 1226C because of the Lake and Riley Act and because of just increased detention. We're going to have more people under 1225B because they are going to be expanding expedited removal, and they're also going to probably be applying that to anyone they possibly could. And we're going to probably have longer detention under 1231 because ICE is going to hold on longer to people with final removal orders, even if they can't realistically deport them. So we'll talk about how we can challenge this expansion. All right, so the best way, or I think the best way to challenge mandatory detention, at least outside of the context of the immigration courts itself, is through habeas petitions. We talked about that more in depth in the October training, and I think Adina will share those materials again when we share these ones. But essentially, this is going into a federal court, federal district court, and challenging someone's detention. It's not an appeal per se. You're not appealing necessarily the decisions that were made in the immigration courts of the BIA, but it is challenging on constitutional or statutory grounds someone's detention. Typically, these habeas claims are based on prolonged detention, and that's what I focused on in the last training. But increasingly under this administration, I think we're going to see more claims and perhaps more viable claims for detention that might just be unlawful from the start or is not really mandatory detention, even though ICE is claiming it. And so there'll be different claims depending on the situation someone's in. Sometimes filing a habeas petition results in someone being released, and that's great. I don't expect that to happen particularly commonly under this administration, but it's certainly happened in the past. And most importantly, getting a positive habeas decision, of which we have gotten many, and many other advocates have gotten great decisions, that helps people. It helps people to be able to cite to it, obviously, in their own cases. But I think there is some evidence to suggest that when we get these decisions, it does slightly at least alter ICE's detention practices. And it's really obviously important that we collaborate on these types of cases. And one of the reasons we do these trainings is that these webinars is to get ideas and to solicit referrals for cases that you all think might be things we can work on together.
Yeah, and I'll just add to, we really started our habeas practice during the first Trump administration when it was so hard to fight in immigration court to get people out of detention. And ever since then, we've really seen the district courts be quite good in these cases. If you're willing to learn a little bit about how to file a habeas in district court, which we have lots of resources to support you with, and we love to collaborate with you on. These cases often do have good outcomes, as Austin mentioned. So it's something just to think about in terms of like putting sand in the grind in the wheels of this deportation machine. Like the more the cases we have, slowing them down and challenging their unlawful use of detention, the more we can just, yeah, slow down that machine.
Absolutely. Okay, so I addressed two of the questions so far in the chat, and then I'm going to answer Chris's question, I believe, in this slide. So, how do we fight the Lincoln Riley Act? I want to just mention again how I foresee this playing out procedurally for you all in immigration court, right? Typically, the first document you get as or your client gets is a notice to appear, right? And that's the information that ICE is, at least the bare information that ICE is alleging against someone. But the thing about the Lake and Riley Act is that they aren't removability grounds. So you're not going to know necessarily, and in fact, you probably won't, that the Lake and Riley Act could come up in your client's case until you actually seek bond, because they're not removability grounds, so they're not going to charge them an NTA. So you need to be aware of how it could come into play. And it's going to be a situation where you move for bond and you maybe are prepared to argue against the Lake and Riley Act if the government raises it. Or if you're so sure that they're going to raise it, then you might just preemptively do it in your bond motion. Amica Center is already seeing this. In one case, it didn't come up. In another case, we're sure it's going to come up, so we're getting ahead of it. So I just want to put that out there. It's important that you, and this is just some of the arguments that I'm starting to look into. The National Immigration Project, NIP, put out a great resource about this that we're going to link at the end of the slides. So you should look at that too. There's a couple arguments to make if ICE says the Lake and Riley Act affects your client. First, retroactive application. There's a lot of case law out there that unless Congress makes clear that a new law is supposed to apply retroactively, that it shouldn't. So if someone has an arrest, even if that even that charge is still pending, but it happened before the Lake and Raleigh Act passed, then I think there's at least a meaningful argument that it should not be retroactively applied. Now, is an immigration judge going to buy that argument? Probably not, but you should still preserve it, right? Because that's the kind of argument that is much more successful in in the federal district court. I don't think you necessarily legally have to preserve it because it's not an appeal, but it's still good to get all these arguments out there. So that's number one, retroactive application. Two, there's significant ambiguity in terms of the language of the statute. It says is charged with, is arrested for, blah 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 blah. So I think arguably, if you were charged with something and that charge was dismissed, right, which I think is Chris's example, especially if you were charged with something and it was dismissed before the Lake and Riley Act, but even if you were charged with something and it was dismissed after the Lake and Riley Act, then you're not currently charged with something. And so I think you could make an argument that is charged excludes that situation, that it would have to be someone presently facing charges. And that it's even stronger for arrested for, because if you are not currently in criminal custody, then I think you can make an argument that you are not currently arrested for this. Now, again, is an immigration judge going to endorse these arguments? Probably not. But it's important that we fight this language, especially because this is like a terribly drafted law that is very clearly just for show, right? Like, no, the Congress people who passed this had no idea what they were doing. That was evident. The Republicans completely put out false messaging about the bill. So like it's not well drafted, and I think we need to fight that. And then finally, definition. So the government needs to show, in theory, that and they did one thing that they did do cleverly here is try to get around what's called the categorical approach. So it says that the meaning of the terms that are described in there, burglary, theft, etc., take on, quote, the meaning given such terms in the jurisdiction in which the acts occurred. So they're trying to get around the categorical approach, which allows us to use the federal definition and compare it to state. That said, a lot of these terms, and this is something I learned from that NIP advisory that you should take a look at or learn more about. Like a lot of these, there's not strict definitions for a lot of things under each state's criminal law. And so, a term might not have an actual meaning, like assault on a law enforcement officer doesn't really exist as such in a lot of states. And so I think you can raise the ambiguity there and challenge that for example, if they're saying that this assault, someone was charged with second-degree assault, and then ICE is saying, oh, but look at the police report, like it involved the police officer, right? But it's actually not a charge for assault on a police officer. I think you seize on that ambiguity and argue that's not it's not a subject to the Lake and Riley Act. There's many other arguments that can be raised, but just raising some of them. And so these are all the things I think are important to do in immigration court, and maybe and appealing even to the BIA. But what we can do, I think, is file habeas petitions after the fact. If the IJ agrees with ICE and says, yes, you're subject to mandatory detention, we can challenge that on two broad grounds. One is statutory, to say that this person shouldn't even be subject to the Lake and Riley Act because of the arguments I just referenced. Or two, and this is what a lot of habeas case law is, we're not disputing that they're subject to the Lake and Riley Act, just as we often don't dispute that someone is subject to mandatory detention, but we say that them being subject to it in this case violates their due process rights. So I'm envisioning a lot of situations. One is retroactive application, right? It does apply, but it shouldn't because it's unfair to apply something from like 20 years ago. Another thing I'm seeing is you are charged with something, you are found to be subject to mandatory detention because that charge is pending at the time. Then later that charge is dismissed, right? And now you're in a situation where if you tried to go back to the immigration judge, they're probably not going to change their decision. But that's a due process problem because the ground on which you're subject to mandatory detention is gone, right? And so I think I think there are ways that this argument can work better in certain cases than others, and it could be coupled with traditional prolonged detention arguments. If someone has been detained, for more than 6 months and they have these arguments, I think that might strengthen it.
Awesome. That was brilliant. Thank you for breaking that down and super practically. I think, those of you, especially in more immigrant friendly states, we want to hear from you if you're making these arguments. We are going to need clients who are represented to make these challenges who can be here long enough to put on a case like that because we know so many people are getting pressured to sign deportation orders quickly, right? Or won't have counsel to fight their case on the merits. So we really need to work together with all of the private attorneys, especially if you have a client that's going to be here fighting, has a viable claim and can bring one of these, reach out to us.
Absolutely. And I'm going to address some of the questions. So I think Marlene responded to Iman. All bond hearings should be recorded. There should be a digital audio recording. You're right that they don't transcribe bond hearings, even if you appeal to the BIA. But I'm dealing with this right now. I'm challenging enforcement of a court order from a habeas and saying that the bond hearings that happened in immigration court did not comply with that order. So I got the digital audio recordings of those hearings and submitted them to the court. You could be right that maybe some IJs don't do it and you should insist on it, but that is a matter of practice. It's just that they don't transcribe them as they do for when you appeal a merits denial. Marianne's question, are you concerned that waiting to cooperate with ICE would be picked up from police stations following arrest? Yes. So the Lake and Riley Act also adds, and I should say there's a whole other section of the Lake and Riley Act giving state attorney generals the power to sue the federal government. It's completely absurd, and I think unconstitutional, and there might be challenges about that. But focusing on this, there is a provision about detainers saying that ICE has to issue a detainer for these people. Now, is ICE going to be able to do that for everyone? Absolutely not. ICE even came out and said that it would cost billions of dollars to implement the Lake and Riley Act. There's no way that under current capacity that they could ever implement it holistically. But we are going to see more people picked up upon their people are going to bail out of criminal custody for a theft. Like they're going to be charged with a theft, spend 24 hours in jail. They're going to bond out or bail, post bail, and then upon their release, from criminal custody, they're going to go to ICE. And this already happens, right? A lot of times, but it's going to happen more often.
All right, ready for next slide?
Yep. Okay, so I focus on the Lake and Riley Act, but I just want to speculate a little bit about other things we're going to see and other things that might raise habeas actions that we might not have done much of in the past. Whereas we focused on prolonged detention in the past, and that's what a lot of the case law is. These are all new things that might come up that we can challenge that don't have anything to do with prolonged detention necessarily. So one is that I foresee them trying to say someone is an applicant for admission in 1225B when they're really not. One circumstance in which I think the strongest argument for this is, and we litigated this, is that we know that under matter of MS, which is a terrible BIA decision, that even if you enter full proceedings after passing through expedited removal, you're still 1225B. But what if you went through expedited removal, then you were released from custody, and then like years later, they re-detain you? Often they will say that you're still 1225B, which is absurd. But we've been able to push back against that because if they re-detain you, they're probably doing it on a warrant, and the warrant probably says we are detaining you under 236A. So there are ways to challenge that. I also foresee, I hope this doesn't happen, but as we see TPS canceled, and as we see visas possibly revoked, um, I suppose if someone's TPS has been fully rescinded and they're otherwise inadmissible, or a visa has been rescinded and they're otherwise inadmissible, then ICE would have the authority to detain them. But I think that the people are going to be detained even if they still have TPS or even if they still have visas, especially because ICE, as you might know, like they're trying to fill quotas, right? So ICE is going to just detain people whenever they can, even though they might not have the authority to do so. In fact, there's speculation that they are releasing people just to re-detain them to meet their quotas. I can't confirm that, but that's what we've heard from some clients. And so I think that's something to be on the lookout for. For example, there is a literal regulation that says you cannot be detained if you have TPS. Will it happen? Absolutely, because ICE does things that are illegal all the time, and we need to be willing to call it out. And then post-removal order stuff. I think this kind of gets to the very first question that was asked in the chat that I tried to answer. So a lot of times people under previous administrations, people have had a final removal order, but then they're released, especially when ICE has had significant trouble deporting them to their country of origin. So as many of you may know, certain countries don't are much less compliant with the US deportation process, which is sometimes a good thing, right? So Venezuela for a while, allegedly that has changed. Some West African countries, Cuba in the past at least. This happened with Vietnam in the 90s. So like a lot of there's certain countries that they just can't, they have had trouble deporting people to, and under Supreme Court precedent and their own regulations, they may have decided to release that person. But again, I think in filling quotas, people are going to show up. People are on orders of supervision. That's what OSUP is. They might have check-ins every year. They go to their check-in. Nothing has changed. The country still is not going to take them back. But an ICE officer sees final order, they're filling their quotas, they take the person. And that we've already seen this happen. So if ICE is re-detaining people who they released on an order of supervision, and there's no real change of circumstance, they can't say that they violated the conditions, or they can't correctly say they violated the conditions, or the country still isn't taking people, right? That's a challenge I think we can make. And this is where I'll bring up the class action. So we litigated to a successful settlement in Virginia, and we're litigating in Pennsylvania too, the issue of ICE holding people even after they win their case, right? So after winning asylum or to some similar forms of relief called withholding or removal or cat protection. So what ICE was previously doing before we sued them in Virginia, and I expect them to continue to do under this administration, is hold people while they theoretically attempt to deport them to a different country. Now, were able to find out through depositions and a lot of research that this almost never happens, but I'm concerned that it will start to happen more legally or not, because as you might see in the news, they're trying to find ways to deport people to different countries, like El Salvador says it will take people, for example. And so, I think they're going to be holding on to people for longer, even if their possibility of removal is speculative. And then finally, I think you should always be on the lookout for, if someone has a final removal order, no matter what the situation, no matter if they're in reinstatement or what, under ICE's own regulations, they have to do post-order custody reviews. They have to review custody at 90 days, 180 days, and every year thereafter. And ICE, especially in field offices that are more that in which they detain more people, like field offices in Texas, Georgia, they constantly mess these procedures up. They either don't do them at all or they do them incorrectly. And I think that strengthens habeas claims, right? For example, if you're arguing due process violation, if they haven't even given the person the thing that they're entitled to by regulation, then that is a due process problem that we've raised. So being on the lookout for all these things. Of course, there's lots of other things that ICE might do, but I just wanted to flag these. And again, I don't want to sound too hopeful, because I understand that this administration is doesn't seem to care about doing illegal things, but at least in past administrations, there is evidence to suggest that the more we challenge this, the more we're willing to do this, the more ICE and DOJ changes their practices, at least on a micro level. I think they expect us to not challenge these things. They expect to be able to do these things to a pro se person detained in Georgia, because no one's going to challenge it, right? But we will, right? And I hope other people will, because we have to challenge these things, or they'll get away with it. Thank you, Evan, for sharing that um, note. And then another question from Becky. Correct. Yeah, that's correct, Becky. So now that they are expand, it used to be that the previous administration's interpretation of expedited removal would be that it's only for people who just entered, like in the last 14 days and within 100 miles of the border. Now there is no geographic limitation, and it's 2 years. So I don't think this is happening quite yet, or at least not on a large scale, because field offices are trying to figure out how to do it. But yes, theoretically, we're going to see a lot more people put into expedited removal, and then they will be 1225B even if they pass through it.
And for that one, that's a good thing to remind your clients to carry evidence with them that they've been here more than 2 years, because it might just be a matter of needing to demonstrate that to get out of that.
And thank you, Lori, for sharing about admission. That's a great point. Another part of the Leak and Riley Act is if you admit to the elements of a crime. In theory, this happens very infrequently. ICE will probably, like, for example, they might try to question your client at a bond hearing or something and try to get to elicit an admission. The actual rules of admission as defined in the INA and in this case are pretty narrow, and you should raise that, right? So like if someone says like, oh yeah, I shoplifted once, right? That's not an admission, or it shouldn't be, to meet the elements. Okay, so I guess next slide, Adina. All right, so this is an opportunity to chime in, and including putting your hand up and speaking. So I'd like to hear about maybe an interesting, maybe not the word, because it's not a good thing, right? But cases you've seen recently of people subject to mandatory detention, particularly in arbitrary ways, and or a particular situation that maybe that I didn't describe that you'd like to see a challenge to. Yes, the slides will be shared.
If you haven't been getting emails from Immigration Impact Lab at amicacenter.org, drop your email in the chat to make sure you get the slides and replay and resources. Apologies for all the back and forth there was recently. We turned off the option for people to email the list. It's not meant to be a listserv, just like a list for us to send updates on the trainings and stuff.
I'm just gonna answer questions, but if someone wants to raise a point, please raise their hand. Um, Wondering about ICE redetaining people that are previously released on parole. That's a great question. We are seeing this. I think that in that case, there would be a couple. Well, first of all, they're probably going to come up with some BS reason for it. So we've seen this a lot, unfortunately, for folks from former Soviet Union countries that were released on parole, and then they'll get redetained and they'll say like, well, you like failed to update your address with ICE or something like ridiculous like that. And so there's probably going to be some reason that they give. Doesn't mean it's a good reason. Um, so I think there are ways to challenge the arbitrary redetention. The problem is they have so much discretion. So I think probably in that circumstance, there might be more traditional habeas claims about access to a bond hearing under 1225B, coupled with arguments about like the arbitrary redetention of those individuals. And, like for example, if the person was redetained with like there was no criminal history, no new criminal history, no intervening history, and there's really nothing that they did wrong, then I think that strengthens those arguments. And then Ariana's question, that is a great question. I don't think they can do that, but I hesitate to say that they won't or can't do anything these days. So the question is, if you are already in 240 proceedings, can they put you in expedited removal? I don't think they can because they or at least they'd have to terminate those proceedings and then place an expedited removal, which I don't think they would do. But again, who knows what these people will do. Valeria has a question. Given that Maryland doesn't have immigration detentions, what do we do to find where an arrested person is? So ICE has a detainee locator, at least as of now. So if you have the person's A number and country of origin, you put it into that locator and it'll tell you where you're detained. The vast majority of people as of now who are detained in Maryland or arrested in Maryland by ICE are at Moshannon Valley Processing Center, a former federal prison in Pennsylvania. Some are in Virginia in the two jails, but they tend to go to Pennsylvania. And we have funds to represent Maryland residents. And so, if you know of a Maryland resident detained, we may be able to represent them in their merits case.
And for folks in Virginia, as of now, we still have our LOP program to still get in there and intake people. So you can tell them to ask to speak to Amica Center.
Anyone have a minute? Go ahead, Adina.
I was gonna add too, for the ICE detainee locator, if you do not have the A number, you can sometimes get it, find out where folks are if you have their birth date and country of origin.
Correct. Let me ask this, have people, because there's been a couple questions about this, have people recently seen their clients or someone's client re-detained at an ICE check-in in the last couple weeks? If anyone wanted to describe that situation. Would you be willing, Alice, to, but you don't have to if you don't want to, but just in generalities, someone granted parole. Yeah, no worries. So yeah, I think that is that we are seeing this too. And I think and I know folks are really busy, so this might not be possible, but like if you can go with your client to an ICE check-in, you should do it, right? Because there is sometimes you might not be able to control things, but I think it's less likely they're detained if someone is watching. So much of this is discretionary. And B, then you can better understand what the purported rationale is, at least, even if there's not a real rationale, because otherwise a client's just going to come back to you likely and say, well, I don't know why they did it. And they're right, they don't know why they did it, but it's important to have this much information that we can get. It's also always a good idea to ask questions of ICE officers, they will probably say things that are incorrect because they don't really know what they're doing. And so like asking those questions, soliciting them to say things that are incorrect, or arbitrary or illegal is positive for challenging it. Danielle, that's great to hear, and I'm sure your clients appreciate that. And Alice as well.
Is anyone able to report back how bond hearings have been going under the new administration? Have you noticed any changes?
Adina, what should we discuss? Still got a little bit of time.
I have a question
Of course.
related to the Lake and Riley Act. You're right, it's so terribly and vaguely written. And I was wondering what people think about people that have so a client that might have an arrest for a theft related charge, like in their country of origin a long time ago and not in the United States, whether that would be something that ICE is likely to look at to support a mandatory detention. So like arrest not in the US.
That's a great question. I don't think, well, I guess it says in the jurisdiction. I think that'd be very difficult to argue. In my experience, I have rarely, if ever, seen foreign convictions even raised as grounds of mandatory detention or removability grounds. Now, they love to raise them for reasons that someone is dangerous, right? So it's as you probably know, they'll like some like illegal groupings charge from the Salvadoran police in 2006. It's like this completely unreliable. We know what the Salvadoran police do. Like it's complete BS. But as soon as you put that before an IJ, the IJ gets concerned. So I think that's more likely. I think you would have a whole host of arguments like, do we even know how the country of El Salvador defines burglary? Like I think that'd be very difficult to show. So I think you should definitely challenge that. And if that is raised by a TA, then I would love to hear about it. And the tough thing about the Lake and Riley Act is like because of the lack of notice, like there are certain situations in which you want to get ahead of it because you know it's going to come up, right? But like you shouldn't assume that a TA is going to make the because remember, and you all know this, right? Like these TAs have so many cases, right? They probably don't have really good training on this, right? So if you have something that like could be Lake and Riley Act, but you're not sure, don't like please don't bring it up, right? Like let the government bring it up and then you might even be admitting to it, right? So don't, and I know that like it's a person's burden. So typically it's a practice, which I get, of like doing a criminal history chart, like just get it all in the open, discuss why it's mitigating. But like with this, I would hesitate to do that. If it's just convictions, fine, but don't like list people's arrests when you think that that could trigger the Lake and Riley, because then you're just making the TA's job easier.
Thank you.
Austin, there was a question about reviewing the arguments about application of expedited removal to people who've been here for many years but have old expedited removal orders.
Reviewing the application of expedited removal.
Reviewing the argument about it. Yeah. If you
Um,
could just repeat that, what you had said.
I see, I see. So, um, well, okay, I'm not exactly sure what it's referencing, but just to clarify one thing, unfortunately, it is very difficult to challenge the application of expedited removal to someone. But my because of jurisdictional bars, but my point was that if you went through expedited removal and then were paroled in the US, like, and then you're re-detained, and I know we're talking about this, like, I think ICE will argue that you're still subject to 1225B detention. You're still subject to the detention as an applicant for admission. And they'll probably succeed in that argument, but I think it's important to push back because when ICE rearrests someone, they normally do so with a warrant, right? So in a case we had, we were able to get all of the records and it basically show the federal judge, like, this literally says they arrested this kid who had gone through, he entered as an unaccompanied minor. He was rearrested by ICE years later, and they did it on a warrant 230 saying like you are being detained under 236A, right? Like that's what they're saying. And so I think it's important in those redetention cases to argue that if they don't otherwise have a conviction that would subject to mandatory detention, right, under 1226C, and they would otherwise be eligible for bond, arguing that I think is important, if that answers the question. I also got a question, and I'm not sure if it was intended to be private, so I won't say the person's name, but the question was, have you heard of approved VAWA clients with final removal orders getting detained? I have not, you know, and I'm unfortunately not super familiar with that area. I wonder if Daniela might know more about that. Um, but I wouldn't be surprised, unfortunately, if that happens.
Awesome. Well, these have been great questions. Just want to mention that oh yeah, we want to ask you all one more thing about like what concerns you have about litigating in federal court. We know that can tend to be intimidating if you're used to immigration court. So this is a good time to just kind of raise anything you're worried about or intimidated of. And hopefully we can make it sound a little bit more doable than it seems if you're new to federal litigation. We do have a really great index of immigration habeas case law around the country that I'll be sharing out after this as well to support you. We have good templates too. But yeah, anyone have a question or thing they want to raise on going into district court for habeas? Or rather, do we have anyone who has been brave and tried and want to share how it went? I might call on Evan see here if you could share your experience because I know you were new to habeas when you joined Amica Center, and like how was that experience learning how to do it?
Sure. Yeah. It's been a great experience. I had practiced removal defense, and had some appellate experience at the circuit court level for years prior to joining Amica Center, but was very excited to learn more about the landscape of detention and had always heard about habeas cases and how powerful they can be to get someone out of jail, out of detention. And yeah, was able to hit the ground running with the support of Austin and the rest of the team, working on a client's case in Pennsylvania for my first habeas. And I really like how straightforward it is. You know, you prepare in a typical case, you're preparing the habeas petition, supported with evidence, and then it happens very quickly that the government has to reply within less than the normal 60 days that they get in normal civil complaints. And then you get a chance to reply, and it applies, significant pressure on ICE to actually release someone, to sort of take accountability for the mistakes that they might have made in someone's case, in order to save themselves the embarrassment of, having a judge publish their mistakes in writing. So it's a great way, I think, for folks to get experience with federal district court litigation and really help an individual and also help push the law forward.
Thanks, Evan. Really appreciate it. Austin, anything else you wanted to add before we wrap up?
If you could just go to the next couple slides, I think just about referrals, next one. So we'll share those resources, and then so we always welcome and I answer a couple more questions. We always welcome referrals for habeas cases. At this time, we are focusing on referrals for the 3rd, 4th, and 11th circuits. So effectively, that is people detained in Pennsylvania, Virginia, and Georgia. And so we are actively soliciting referrals for those cases. And in fact, we got a referral for a great case in Georgia that I just filed yesterday, I think through one of these roundtables from a private attorney in New York. So if you have that, you can email the referral lab@amicacenter.org. There's actually we can send you the form when you email it to us, but there's actually a form on our website for like the kind of information we want. And so in general, we are looking for the basic information about the procedural posture of the case, whether they've had a bond hearing before, a little bit about their criminal history, just so we can understand what, ICE may have what ICE's purported reasons for detaining them are. And to kind of go through that, and then we can see if we can take on the case either ourselves or through pro bono. So please refer those cases if they are in the 3rd, 11th, and 4th. I won't put others on the spot, but there's others who do great work in other circuits, especially some that do some great work in the 2nd. So I think it's really important that we share resources, share referrals, and try to do this as much as possible. And then Adina answered that question. And then there was another question, again, private to me. I'll answer that in the chat. But go ahead, Adina, if you want to talk about the next roundtables.
Well, yeah. So given how crazy things are, this year we're doing these every other month instead of every month. So the next will be April 3rd. There's still the first Thursday of every month, every other month at 3 Eastern. We are, I think, gonna play it a little bit on the topic rather than planning it out for the whole year, given how much crazy shit is changing every day. But we do want to hear from you what you all need training and guidance on or want to talk about strategy on together. So please reach out if you have any requests. We'll definitely take that into consideration. And thank you so much for being here. I'll be sending out the replay and resources that have been mentioned, and keep up the amazing work, everyone. Thanks for taking the time to learn about challenging detention today.